Good morning. I'm Troy Wharton, Director for Student Affairs at Boys Town. We're Group 3, and we will be sharing Chapter 13, Managing Conflict in Schools. Uh, Chapter 13 will cover the nature of conflict in organizations, methods of resolving the conflict, managing conflict through the grievance process, arbitration of work, rules, and other issues around arbitration. One of the things that it states very early in the chapter is that obviously, with human activity, um, there's going to always be some sort of conflict when there's multiple people involved. Um, the four areas that we see in the workplace, especially in schools, is disputes regarding the allocation of resources and privileges, disagreements about the application of laws, rules, and policies, confusion about duties and responsibilities of employees, and finally, disagreements about employee evaluations. So the dispute over resources. Typically, you want to try and allocate resources based on your mission and your priorities within the school. In order to do that, it's important to try and come to a consensus where everyone agrees. But even with focusing on mission and trying to come to a consistent consensus, there still may be disagreements based on program importance. For example, large programs such or sanctioned programs like band may need more funding than some of the smaller or non-sanctioned programs, maybe some of the school clubs, and those types of disputes continue based on, maybe who's in charge. They in charge of those or lead those particular areas. So coming up with a consensus is good. Making sure you focus on your mission and your priorities. The application of rules. Um, the rules and policies that are determined by administration, we got to make sure that they're clear, they're defined, and that they're communicated with all those who are involved. And even when that is done, there's still interpretation. Some things are still left open to interpretation by maybe by certain folks. Um, for example, the question comes like, what constitute as an emergency? And in the book, one of the examples was that a teacher needed to go pick up their prescription medicine, and the administrator did not see that as an emergency. They felt that that was sort of a daily routine or kind of a routine duty as a person. Um, so, what constitutes as an emergency? Is it something that's unforeseen and you have to get up and leave immediately? And who gets to determine that? The one thing that the book really focuses on, though, is once you make a decision, you set a precedent, and once you set that precedent, you have to make sure that you continue to follow that precedent that you've already set. Anyone has anything? I'll
No, but
continue.
I do
Go
know
ahead.
that I think consistency is a theme we see throughout this chapter for sure. Because I talked a little bit about that too, just being consistent. Like I said, set that precedent and stick with it.
We ran into a lot of that this year. So I don't know if you know, you probably don't, but Boys Town is building a new school. We got like a $48 million school that's being built. So for the past 2 years, we've been spread out on campus in three different buildings. So we have our ninth and 10th graders in one, our middle school students are in another, and then our 11th and 12th graders are in another. And one of the things we ran into was our administrators. Um, we'd have one administrator in each building, and the thing that continued to come up, well, when I'm in the 910 building, they just let us go and run to the store if we need to during because we've got 95-minute blocks. But then when I come to this building, I'm being told that I have to sign out or I have to get approval. So that was something that we ran into when we're talking about this applying rules and making sure we're consistent. So we had to have a quick huddle to come up with what we were going to do. So it'll be nice to be in one school building again next year. So I'll go ahead and move on to confusion over duties. Another example or another issue where we have to be clear. We have to make sure we state with all employees what their duties are, the job descriptions, working with HR, making sure the job descriptions are clear. Um, and again, there's a lot of interpretation of that. And during the reading, there's a section where a para is asked to aid two students with a reading assignment, but the para feels like they're not qualified because it feels like she was having to teach and not aid and not be a para. And she felt that that duty was above and up beyond her responsibilities. So making sure that we're clear with the duties prior to people accepting positions. And then lastly, the evaluation questions. Um, there's just a lot of feelings and emotions in evaluations by the teachers, and understandably so. It has implications for their jobs, for the positions that they hold. And during the evaluation process, it is clearly discussed that we should allow teachers to know and understand prior to their evaluation what they're going to be evaluated on. And then that way, we want it to be less subjective. They know what they're being evaluated on. Um, the other thing that teachers really would like is for consideration and context to their evaluation. And one of the examples that's used is if you have a teacher with a low performing, teaching a low average or below average performers in a classroom, how different that class may be behaviorally compared to a high performing class, and being able to move through the content quicker, being able to teach longer, be able to not have to address more behaviors. But teachers really would like to have or see some sort of context put into evaluations based on who they are teaching. The last thing I would say, I would encourage you to look at pages 250 and 251. There's to go into the actual examples in a bit more depth if you would like, but pages 250 to 251 references what I just discussed. Thanks.
I know at Cedar Bluffs, we spent quite a bit of time building our evaluations with staff. So we really worked through and kind of built a rubric with them and took their input, so that they were really involved in the evaluation process. Is it a perfect tool yet? Probably not. There's still always some growth to be had, but I thought that was a good way to build that evaluation tool.
Well, and that's one of the things I've noticed as well too, is that, maybe if a person doesn't completely agree with what's happening, they're more likely to get on board if you're clear with what's going on and you communicate all of those steps throughout the way. All right, which leads me into objective number 2. My name is Mike Ziola. I'm an assistant principal at Columbus High School. Objective 2, examine methods of resolving conflict. So in this section of the book, it basically runs from 253 to about 255. It talks about 4 different ways to hopefully resolve conflict. And so I'll just kind of go through some of the things that the book said. The first one that it talked about was mediation, something to use to help all parties consider issues at work, identify common interests for settlement. Now, a lot of what it talked about in the mediation section was the emotion that's involved from each side. So obviously both parties are going to be pretty passionate about their beliefs, their stance on whatever the issue might be. As a mediator, you might be meeting with the parties separately. So hopefully that you can understand where they're coming from without that emotion involved. And then hopefully bring the parties together and create an atmosphere that isn't hostile, that both sides can view it factually, but sometimes it works and sometimes it doesn't work. As I was reading this, it kind of reminded me, a friend of mine is a lawyer, and he used to mediate in divorce court. And so he spent a lot of time mediating, and one of the issues that they had was they spent 4 to 5 hours mediating between who gets what between both parties. and they spent about 2 hours on a Tupperware set. And they ended up having to go to lunch. And as I was thinking about this, my lawyer friend told me as he went to lunch, he went and bought the same Tupperware set at Walmart and brought it back and gave it to the other party. And that person said, "I don't want it, I want mine." And so as I reflected on this in the educational setting, sometimes it's not about the thing or the object or whatever it might be. It's getting your way. And just being able to understand that as a mediator, as an administrator, in whatever the situation might be. It could just be a deeper rooted cause in that situation. The second one is arbitration, similar to mediation, but this one, both parties are just going to have to accept what the arbitrator comes up with. The pros are that it's going to be quicker. It's probably going to save the district money and time. The cons are neither party is happy, but I guess sometimes that's kind of what compromise is in itself. Each side may present a final offer onto where they're willing to move to, which may or may not be accepted by the arbitrator. The third one, ombudsman. I think in a school setting, this is mostly going to be seen kind of in the special education realm. Really what it talked about in this situation was this is an individual that really helps, parents or somebody from the outside understand the bureaucracy or all of the paperwork that goes into, in this situation, school setting. And so if you're not living in the educational realm, obviously something like special education can be really confusing. Even if you're in the educational realm, all of the laws and everything that goes along with special education can be confusing. And so this individual can help kind of navigate that paperwork, some of the language that goes along with that, to help everybody kind of understand what's going on and hopefully come up with some type of conflict resolution. And then the last one is kind of the goal, I think, as administrators, you're searching for in your building or in your district is just kind of that culture of cooperation, the ability to speak truths, get all parties involved, deliver the mail to the proper people. And so this can be done through school leadership teams, whether it be curriculum directors, professional development teams, just using all of the resources at hand, having open communication and just creating that culture of cooperation. It's easier said than done. But school districts that are able to do that can avoid kind of these first three things that we talked about in this objective. So with that being said, if you guys have anything to add, go for it. Otherwise, we can continue on.
I know your objective 1 and 2 kind of go together there. I was thinking of, with our teams and so forth of, being consistent with those teams and the decisions that they make sure they're consistent as well to help, with buy-in and trust from others and that. So, kind of theme of just being consistent and once you make your case, you go forward and like there'd be a lot of different arguments. Your example of the Tupperware was a great one, Mike.
Well, my Tupperware set.
Exactly. And it, like you said, it's not always about the Tupperware,
No.
whatever the Tupperware might be, that's not always what it's about.
I think a lot of times it's about being heard too,
Mhm.
more so than whatever you're actually arguing over.
Right.
So
Right.
We've been working with some parents. So here our students that are on campus live in homes with what we call family teachers. So that's their professional parents, I would say, because they live here on campus. But they come from all over the country. So we get all of these IEPs. So it's been challenging. We've had some districts and parents that are suing districts, and we have to get in the middle of it to show them how we're serving IEPs. And it's been really eye-opening because we got kids from, you name it, and they may be the state may be represented, and you would never realize how much people, how districts want to reach out now, because when they start losing funding because a kid is here and the funding's coming here, but we're gonna send them back, and there's been a lot of stuff where we've had to use our legal team here to get involved in some of the IEP. So to your point, the special ed is really tricky, very, very tricky.
Moving on here, objective 3 here. I'm Dustin Nielsen, elementary principal, Emerson Hubbard Elementary School, and objective 3 discusses the steps of how to manage conflict through the grievance process. And the steps involved, the steps might look a little different or be shortened up or combined a little bit depending on the size district that you are in. But in general here, obviously, written grievances submitted, and they have a nice simple example there on page 257. And then step 2 there would be the administrator meeting with the individual that filed the complaint and later announced a decision. If appealed, the grievance is heard by a director of HR or the assistant superintendent or superintendent, depending on the size of district and so forth, and the decision is announced. Again, if it's appealed, referred for arbitration or mediation, which Mike talked about, and so forth there. The school board may also get involved in review and approve or disapprove the decision. Again, in some districts, the board may hear the complaint earlier, or the steps might look a little bit different or combine a little bit if there are a smaller district and such. Like we've mentioned here, interpretation of the negotiated agreement, contracts, and so forth is very important. You have to consider the contract itself, the exact language of the contract when filing a grievance. Rules of interpretation simply means that the words that are in the contract should be given their generally accepted meanings, and not trying to sway things one way or another, but can be difficult. But that is one way that you need to make sure that you look at the contract closely and follow that, so that you have the rule of interpretation correct. Also, I had objective 4 there, discuss arbitration of work rules. And there are different rules, 3 of them, that can apply to this. And principals are largely expected to discuss these disagreements with the involved parties, like we mentioned, individually and such. But the 3 questions that need to see if they apply in these cases are what action of activity is covered by the rule, under what conditions is the activity appropriate, and to whom does the rule apply. Those will be looked at upon the filing, and see which one or a couple of them apply in your case. Talk a little bit about grievances on evaluation. Again, must follow the language of the contract. Any departure from that will most likely be rejected. Use of information not obtained by classroom observations is acceptable. That is brought up in the chapter here, unless it's specifically prohibited according to your contract. So again, reading through the contract to see exactly what is permitted and what is not permitted for grievances and such. Negative norm setters. Again, these individuals are ones who break rules and policies, establish the behavior standard for all employees. There's a great example on page 259. So again, once that person has an issue, you're setting the tone and expectation moving forward, and being consistent. Non-compliance with work directives, non-instructional duties, including voluntary duties. Again, reading that contract to see, are your duties, is it assigned or is it voluntary? That can obviously play a difference. And lastly, if nothing's mentioned in the contract, the arbitrator will look at past practices and use other factors to weigh decisions. Page 260 there, it talked about example of a cheerleader sponsor resigning mid-year, and how that was dealt with, as there wasn't anything in the contract about how to handle that and such. So again, making sure that your policies and contracts and handbooks are all accurate and say what you want them to say is huge when you get to these to this chapter and so forth, and will help your district tremendously.
I don't know about you guys, but when I read that negative norm setters section, somebody popped into my head right away.
Oh, yeah.
There's always one or two that do seem to negatively try and set that bar for everybody else, and that creates kind of an interesting dynamic there.
Yeah, and
Yeah.
I think about with individuals like that, the importance of just documentation. To have a contract that has every single thing a person might do outlined in it is really difficult, but documenting behavior. And then one of the things that we look at Columbus is just professionalism. We kind of keep that umbrella that kind of takes all of that into account, and just some things that we look at. And unfortunately, no matter where you are, there's always one or two, negative norm setters.
Yeah, for sure. All right. Moving on to objective 5. I'm Kate Chrisman, the Career Academy Director at Cedar Bluffs. And in this final objective, we're looking at examining other issues in arbitration. I kind of chuckled when I started on this section because I think that they gave it to me to see if I could trip over the word arbitrability when I was talking about it. So arbitrability refers to whether a grievance is subject to arbitration. So there's a couple of things like grievances that deal with powers granted to the board by statute. Those are not able to go to arbitration. Also, if they're not timely. So there's a lot of things dealing with timeliness that you cannot take to arbitration as well. So there's a section of timeliness talks about teachers having to file a grievance within a certain number of days. And that's typically listed in a policy of like what that timeline is. So they didn't give you an exact timeline, but you need to make sure it's documented. And then equally, administrators have to respond within that timeliness. It's very likely that in arbitration, an administrator would lose if there was a delay in a response. In the same way, a teacher couldn't take their problem or their grievance if too much time had passed. And then they're talking about questions of law. So arbitrators must be familiar with relevant court decisions. They're guided by other decisions. Again, consistency, right? So if in this situation it went one way, it would likely go that same way. One of the examples they gave was the Twinsburg Board of Education and Support Staff versus the Ohio Education Association. Basically, an aide had asked to be reassigned because of a back injury, and they denied her request. So she filed a grievance referencing the ADA. However, her grievance was denied because they looked at another court case, so Thompson versus Holy Family Hospital, and that meaning of the ADA did not apply to her back injury. It was not actually classified as disability. So again, just being aware of relevant court decisions. Another thing is past practice. Again, that consistency. The administrators should work to follow past practices when deciding grievances and following consistency over time. So they gave an example of the Stryker Board of Education versus the Stryker Education Association. So, and I feel like this is probably something that most administrators deal with at some point, a similar example. Teachers' plan time was shortened. In their contract, it was said that they were supposed to have 200 minutes a week of plan time. And it was always during the specials period for elementary specifically. And so when they changed that specials time, their plan time was shortened. The board basically said you can use your on-duty time before and after school to make up for those number of minutes. So they're still meeting the minutes. The association argued that this violated the agreement and was not past practice. They'd always had this amount of time during their day to have a plan period. But the grievance was rejected, basically that past practice was not relevant in this situation, and that they were still being given the minutes that the contract had noted. So again, while you want to stay consistent, it isn't always, it comes back to kind of that being familiar with relevant court decisions and how those all kind of play in together. And then the effects of arbitration on the district. I thought this was kind of important, even though not a huge section. It doesn't fare well. Once you're in arbitration, again, both parties are probably going to come back not pleased, not happy that nobody gets their way. So it just creates kind of a damper on personnel and overall policy. So most administrators really attempt to include language in the contract that defines what can be taken to arbitration and keep it very small, what would allow to go to arbitration. The book said that some administrations never go to arbitration unless they're certain they will win, which is, I don't know if you can really ever be certain, but if you feel very, very confident that, you know, everything that you've covered is there and in writing. So yeah, so just kind of being aware that arbitration could kind of have a negative impact on your district. I don't know if anybody has anything to add on that.
That's why the lawyers make the big bucks and always have a full house at admin days in July there.
For sure, yeah.
To hear their stories, and you hope it never happens at your school, but some of it's crazy and some of it's day-to-day stuff like the example you provided.
Yeah, that's what I felt. If all these examples felt really, really possible and relevant. But you know, you'd hope that you can kind of work it out just in mediation or in open conversation. Okay, well, if that's everything, then that's the end of chapter 13. And I think we'll go ahead and stop there.